In case of any queries, questions arising, please post them in the chat box. We'll be taking them up. TERI School of Advanced Studies welcomes you all to this webinar. It's our honor and privilege to have with us Mr. Gopal Subramaniam, Senior Advocate, Supreme Court of India. Sir is one of India's foremost legal luminaries. In his long and illustrious legal career, Sir has worn many hats. And I should point out here that he is one of the youngest lawyers to be designated as a senior by the Supreme Court, and he has also went on to serve as the Solicitor General of India. We welcome you, sir, and I'm sure our participants will immensely benefit from your vast knowledge and experience. I would also seize this opportunity to briefly introduce my university to you, sir, and to the participants. TERI School of Advanced Studies is probably the only university in the country which envisions to build capacity around various themes of sustainable development. The Center for Postgraduate Legal Studies at TERI School of Advanced Studies offers master's and doctoral programs in legal studies. More specifically, our LLM is offered in specializations of environment and natural resources law and business and infrastructure law. I must here place on record that our Center for Postgraduate Legal Studies
Ma'am, somebody muted you, so please unmute yourself.
Sure. Thank you. Thank you. Sir, our LLM master's program is offered in environment and natural resources law and business and infrastructure laws. And I must add here that our Center for Postgraduate Legal Studies have had the privilege of having sir's guidance and blessings in one or more ways. Thank you so much, sir. We look forward to today's discourse.
Thank you for inviting me to speak on a subject which has contemporary relevance and importance from different perspectives. I am a constitutional lawyer, but I believe in interdisciplinary contextual interpretation of the Constitution. So I do hope that I will be able to share with you today my perspectives, not only from the standpoint of a constitutional lawyer, but hopefully what I see as the larger questions which are being thrown up by this very topic for discussion. The first is that I have lamented, and my lamentations don't cease, that the Constitution has never sufficiently been spiritually grasped as a charter which defines more accurately the outward traits of a meaningful existential life. It is not simply a pocket of rules, or shall we say sections or articles. It is the embodiment and recognition of many natural rights. The moment we acknowledge that our Constitution does no more than incorporate basic human natural rights, we must try to see what are the implied rights in those natural human rights. According to me, Under Article 21, which talks about life, which talks about dignity, and the Supreme Court has now interpreted without a manner of doubt that dignity is inherent in Article 21, is the right to health not an ancillary right? I want to say it is a fundamental aspect of dignity. I will come to many countervailing arguments on the subject, and the usual, shall I say, argument on the other side is that there are never uncontrolled resources to deal with healthcare, and how can this be a fundamental right which can be charged against the state? But that is really, shall we say, the important point to be considered. The point to be considered is, what is the perspective of those who deal with the Constitution? Do they look at the right to health as an inclusive right? And, if I may say so, the International Covenant on Economic, Social, and Cultural Rights called these as the underlying determinants of health. What were they? Safe drinking water and adequate sanitation. We are here in the year 2020. In the year 2020, we are talking about adequate sanitation. Number two, safe food, a very relevant consideration. We have had judicial interventions by the Supreme Court to see that the midday meal schemes for children was effectively implemented. Number three, adequate nutrition and housing. The Supreme Court actually, with the help of civil society, wanted to determine what should be the minimum acceptable levels of nutrition, healthy working and environmental conditions. You have seen what happened at Visakhapatnam. Where are the healthy working and environmental conditions? Health-related education and information. We are now, of course, having a surfeit of health-related education and information because of COVID-19. And lastly, gender equality. Who is made to work more in the construction industry? Is it the woman or is it the man? I raise these points because they're fundamental to understand the subject of what is meant by right to health. Right to health is not a utopian right. A right to health is what we call as a translational right in reality. The fundamental freedoms also include certain other aspects. The right to health includes to be free from non-consensual medical treatment, such as medical experiments and research. It definitely gives you a guarantee against forced sterilization. It is also a guarantee against any form of torture or cruel or inhuman or degrading treatment. The right to health has many entitlements. At the systemic level, there must be a health system which gives equality of opportunity for everyone to enjoy the highest attainable level of health. The right to prevention, treatment, and control of disease, access to essential medicines, maternal, child, and reproductive health, equal and timely access to basic health services, provision of health-related education and information, and participation of society in health-related decisions, both at the national and community levels. I make a point in a present context. Non-discrimination is absolutely essential in the matter of provision of health services, in the matter of goods and facilities, which must be provided to all without any form of discrimination. Now, let us come to another aspect about the right to health. And there we have three vulnerable groups of people. A, people with disabilities. B, people who are elderly. And C, people who are mentally ill. They also come under the gamut of what we call as the right to health. First of all, we must understand that we are not the subject of a charitable dispensation under the Constitution. The Constitution is not an instrument of benevolence. It is an instrument of rights and duties. It is an instrument of charging obligations on the state. It is an instrument from which humans and the citizens can expect due process, but due process not only in procedural forms, but in substantive forms in the context of health. Let me take this a little further. In international human rights law itself, being a part of the International Covenant of Economic, Social, and Cultural Rights, the instrument of protection for the right to health recognizes the right of everyone to the enjoyment of the highest attainable standard of physical and mental health. Now, I wonder, we have signed any number of conventions, and as all of you know, our Constitution, which was actually enacted after the United Nations Declaration of Human Rights, incorporated those rights as a part of Chapter 3 of the Constitution. Chapter 3 of the Constitution does not speak about constraints of the state. And this is a little important for us to understand, because in the abundant measure of discourse which I see discourse of people who are dealing with issues of management. How do they deal with issues of management? They deal with issues of management through two metaphors. One of them is called numbers or statistics, and the other is what is called resources. So we have an interplay between numbers and resources at recurring points of time, losing sight of the fact that it is the individual citizen who has to be guaranteed and fulfilled that right of health. So suddenly the discourse actually changes differently. What about communicable diseases? What about non-communicable diseases? What about graphs? What about curves? Have curves flattened? These are not, with respect, the way by which we judge what is a constitutionally guaranteed right to health. The right to health does not depend upon the fact that only a few tens or hundreds died in a million. It is not an answer to say that yes, in malaria we are performing worsely compared to certain other countries, but in some other diseases we are better. These are completely irrelevant to understanding that the right to health must not be confused with what we call as the dimensions of management of the subject in a public health discourse. In a public health discourse, you use numbers, models, graphs, and anything. But in terms of jurisprudential obligations and rights, they are completely extraneous. And that is why numbers are not the means for justification. And I'll develop this point a little later. The covenants, which are the international covenants, and 12.1, for instance, in subclause 2 provides that the steps to be taken by the parties to the present covenant to achieve the full realization of this right shall include those necessary for the provision for the reduction of the stillbirth rate and of an infant mortality and for the healthy development of the child. And please park female feticide here on the side. 2, the improvement of all aspects of environmental and industrial hygiene. Very important question. This is something which I do wish to emphasize. C, the prevention, treatment, and control of epidemic, endemic, occupational, and other diseases. Well, we are right in the middle of one of them, the pandemic. The creation of conditions which would assure to all medical service and medical attention in the event of sickness. Now, we have had various subsequent international and regional human rights instruments to address the right to health. We have had the international human rights treaties, which recognize the right to health, the 1965 International Convention on the Elimination of All Forms of Racial Discrimination, 5E4, the 66 International Convention on Economic, Social, and Cultural Rights, Article 12, the 1979 Convention on the Elimination of All Forms of Discrimination against Women, Articles 11.1f, 12, and 14.2b, the 1989 Convention on the Rights of the Child, Article 24, the 1990 International Convention on the Protection of the Rights of all migrant workers and members of their families, Articles 28, 43e, and 45c, the 2006 Convention on the Rights of Persons with Disabilities, that is Article 25. Of course, everybody knows about the Declaration of the Alma Ata, the Millennium Development Goals, and various declarations and commitments which have been made in different parts of the world. We also have its recognition in the African Charter on Human and People's Rights, the additional protocol to the American Convention on Human Rights in the area of economic, social, and cultural rights, called the Protocol of San Salvador, the European Social Charter, then the American Convention on Human Rights, and the European Convention for the Promotion of Human Rights and Fundamental Freedoms. Now, some of the constitutions, like South Africa, Chapter 2, Section 27, in the context of health care, food, water, and social security, have said everyone has the right to have access to a healthcare service, including reproductive health care, sufficient food and water. The state must take reasonable legislative and other measures within its available resources to achieve the progressive realization of each of these rights. No one may be refused emergency medical treatment. Well, I think all these three aspects, which you find in the South African Constitution, in my submission, are actually embedded as a reading of two articles of our Constitution together. One is Article 47, but 47 is to be read into Article 21. And if you did so, Article 47 articulates a duty of the state to raise the level of nutrition and the standard of living to improve public health. Incidentally, the Constitution of Ecuador has Article 42. The state guarantees the right to health, its promotion and protection through the development of food security, the provision of drinking water and basic sanitation, the promotion of a healthy family, work and community environment, and the possibility of permanent and uninterrupted access to health services in conformity with the principles of equity, universality, solidarity, quality, and efficiency. Now, these words have some meaning. Equity, universality, solidarity, and incidentally, in our constitution, we use the word fraternity. Quality. The word quality is very important here. And efficiency. And then to select groups like those who live with HIV or AIDS, there is the duty of the state to treat them. And in fact, many civil servants took initiatives in the government of India to offer the best of treatment to people who were likely to be stigmatized by society, and also evolve systems by which the stigmatization could be avoided. The question of protecting women in the context of poverty and economic dependence and in a patriarchal society is a matter of considerable concern. The fact that COVID-19 has shown something so demonstrably, so vividly, and so picturesquely is, while we can claim equality, while we can suggest that we are not a patriarchal society, while we suggest that all men are born equal, but in the translation of human rights to move freely under Article 19(1)(d) of the Constitution, the ability to live with dignity, to return to their homes, they were classified as a class of humanity who bore a name called migrant labor. That expression was itself, in my view, seriously pejorative. One must know that the use of the expression labor is of some significance in constitutional jurisprudence. Forced labor is prohibited under the Constitution. This influenced the Supreme Court to take recourse to various measures in public interest litigation. In the early years, when the Supreme Court chartered on this course to free what were called as bonded labor, the judgment of the Supreme Court in the Bandhuva Mukti Moksha, after weeks of sustained hearing, to free people from debt and bondage, was in furtherance of the principles contained in the Constitution. And indeed, it is a matter of some concern that today we have Article 23, traffic in human beings and begar and other similar forms of forced labor are prohibited, and any contravention of this provision shall be an offence punishable in accordance with law. But it is not only these individuals. We are now looking at something else. We are looking at health of these individuals as well. And we are looking at the health of those who have been removed by what is called as social distancing. I touch upon this point because there cannot be two standards of public health in a society. There cannot be a standard that the poor, without recourse and facilities to be taken back, are unable to comply with what is stated to be relevant for the non-spread or the halting spread of the disease, while others who are in a position to quarantine or live safely in their homes and apartments actually have the ability to say, we do not want anybody to come near us because we want to be safe. The standards of safety in public consciousness has to be the same. In the practice of that standard, the Constitution contemplates a uniform standard in terms of public health. I recently read an interview by a very eminent public health analyst, one of the most foremost gentlemen. He spoke about figures per million in India, per million in UK, per million in United States, per million in Belgium, and how we possibly fared better. But at what cost is the question. What is our understanding of the right to public health of the people who are moving in the road? If they tested positive, what would be the obligations of the state? This is an important question. Look at women. If you see the pictures, you see women, obviously, they all belong to certain forms of sectors, some sectors, like construction sector, agricultural sector, they all are walking unmindful of healthcare. And is that not significant? How is that discrimination? In case they were tested positive, how is it that they are going to be addressed? Now, keep in mind the Convention on the Elimination of All Forms of Discrimination Against Women under Article 14, which actually calls upon states to ensure that women in rural areas, they participate in and benefit from rural development and have access to adequate healthcare facilities, counseling, and services in family planning. Children. What about children? What is the right to health which is guaranteed to children, both for physical as well as for mental development? What do you do with children who are exposed to malnutrition and infectious diseases? How do you deal with issues relating to situations of substance abuse, alcoholism, as well as lack of mental health? These are all different facets of the right to health, where the obligation of a dynamic state-citizen interface is actually guaranteed under the Constitution. I'm going to give you an example. Sheila Basse is a very well-known and respected journalist in Maharashtra. She filed a public interest litigation that some people were reportedly in jail, but not for any crime, but because they were perceived to be mentally ill. The court inquired into the matter and struck down all these detentions as illegals. Think about it. The ability of the state to rehabilitate people is also a facet of the right to health in respect of these cases. That is why there has to be, in my view, first and foremost, what we call as the society-oriented perception of the Constitution. If we do not view the Constitution as the able deliverer of these rights to people, then we have them only in some forms of discourse. But human life can't be measured in fragments of charity. Human life, if it has to be given a certain advanced meaning, it must be one which is at least free of minimal afflictions. Look at facts. Childhood deaths can be attributed to respiratory infections, diarrhea, measles, malaria, malnutrition. And we have had how many commissions? But there is one report, the Sheltam Commission, that is one, that's 2014, where there were about 20 recommendations, in my view,
बुआ तो नहीं रो रही है
are very essential.
नहीं बेटे मम्मी ने बुआ की आवाज सुनी बुआ
They
तो
are
आपको रोकता
very
Sir, you are not audible. The mic is off, probably.
Can you hear me again?
Yeah, we can hear
Sorry.
you now.
Yes.
Yes. So I said the Chaltam report in 2014 is a very good document. It has been very well made. It has a way forward for the purpose of how states can actually progress forward in making sure that in matters of healthcare, there is a fundamental responsibility. They suggested that a minimum of 5% of GDP must at least be allocated for the purpose of the state and its infrastructure. But according to me, depending upon the population of India, the figure of 5% may be even less. We may need more. But this is a long-term investment in securing two things. First of all, it secures the most important but sometimes inarticulate premise of equality by upliftment. The second is it creates better conditions for performance and fulfillment of human potential. The other aspect which I wanted to bring to your notice was people with disabilities. Indeed, I have seen some of these protagonists who with such enormous energy fought for the implementation of the laws relating to disabilities. And the newly adopted Convention on the Rights of Persons with Disabilities now requires states to promote, protect, and ensure the full and equal enjoyment of all human rights and fundamental freedoms by persons with disabilities, including their right to health and to promote respect for their inherent dignity. Migrants, I have already alluded to it. The International Organization for Migrants says that nearly 200 million international migrants exist all over the world. The International Convention on the Protection of the Rights of all Migrant Workers and members of their families, in Article 28 stipulates that they must have the right to emergency medical care for the preservation of their life, the avoidance of irreparable harm to the health, and also to enjoy treatment which is of an egalitarian character. Now, how did this right to health actually evolve by courts in India? Again, it was an activist court. It consisted of brilliant activist judges, Justices Chandrachud, Justices Krishnaya, Justices Bhagwati, Justices Chinnappa Reddy, Justice Desai. And that is why in Francis Corelli-Mullin, they relied upon a dictum of an earlier judgment, which was in fact rendered way back in the United States in the late 19th century, and said, by the term life as here used, something more is meant than mere animal existence. The inhibition against its deprivation extends to all those limbs and faculties by which life is enjoyed. The provision equally prohibits the mutilation of the body or amputation of an arm or leg, or the putting out of an eye, or the destruction of any other organ of the body through which the soul communicates with the outer world. This was then furthered in relation to care in government hospitals in Paschim Banga Hit Mazdoor family. That was a decision rendered in 1996. And indeed, there the Supreme Court said, let's be very clear, we're talking of a welfare state in the Constitution. This is a government to secure the welfare of the people. Providing adequate medical facilities for people is an essential part of the obligations undertaken by the government in a welfare state. And then the Supreme Court says, Article 21 imposes an obligation on the state to safeguard the right to life of every person. Preservation of human life is thus of paramount importance. In 1998, again the Supreme Court said, provisioning for public health was the primary duty of the state on the following terms. It said again, further to secure, and no, I'm sorry, there's an earlier line. The court has time and again emphasized to the government and other authorities for focusing and giving priority, and other authorities for focusing about health of the citizen, which not only makes one's life meaningful, improves efficiency, but in turn gives optimum output. And then it said, this is an obligation under Articles 21 and 47. Now let's look at the figures. What have we spent on our public health? 1%. Then there was a publication which said for the year 2017-18, for 1.02 for 2016-17, 1.28 for 2017-18, and of course we are contemplating to increase it somewhere around 2.5 to 3%. But I have a slightly more fundamental issue. We've talked about communicable diseases, non-communicable diseases. We have studied their profiles. We have said how we are doing, how we can actually replicate many of these wonderful NGOs across India, so on and so forth. But I need to make a small mention of a very interesting passage, which was written immediately after the Ebola outbreak. That gives me an idea that all this was actually in the offing. Ilona Kickbush wrote, the Ebola crisis has brought the issue of global health security back on the political and the technical agenda. There is much debate on how the governance of global health security will be reformed, especially in a context in which the shared global space of threat seems to expand and is not matched by shared global space of responsibility. It is one thing that all this started way back with reference to a common doctrine with reference to sanitation. From there we proceeded to the WHO, SARS-1, H1N1, H5N1, avian flu, Ebola, Zika. We've had so many. But there does not seem to be a fundamental interface on the issue of the right of health in respect of a citizen at one level, and the right of society to be safeguarded against pandemic at another level. The two should not merge. This is very important. Unless the first is firmly established, the second will never have full force. The second then will be only a matter of transient cacophony. What might happen is at the end of the day, we will have figures, we will have visions, we will be promises, but there might still not be the fundamental right to health. I'm going to conclude leaving you with a very important thought, because this is a difference in the sociological approach of sociologists, health experts, public analysts, and field workers. And this must be brought to your attention. One set of people refer to the poor, to the weak as a class, suggest what is called a cash transfer, what is called additional few kilograms from the PDS supplies, but they're still looked upon as a class. What is their position individually as citizens of the country with independent personality? That is why we do need to move from a model of statistics to the model of individual criteria in respect of people. And there, the state must evolve, according to me, a reflective model of the strengths and weaknesses of the individuals within the unit. The very purpose of decentralization under our constitution was to empower the local bodies, because the local bodies were the ones who were closest to the people and could be held accountable by the people in terms of authority. The modeling which is done, even by the most eminent of economists, with reference to a collective group and a collective cure, is very different from a field study, and on the basis of the field study, new requirements being devised. One example, you should be aware that it was only when a nutritionist went into the remote villages of Andhra and actually discussed with them their dietary intakes, he came to know that iodine was absolutely essential because of the levels of malnutrition in that particular community. So there is no hard and fast rule which can actually be a solution. What is necessary for a solution is a newly innovated strategy where, instead of there being class formulations or general formulations, there must be more individualistic standpoints and access to them to discover their true problems. I thank all of you. I have, of course, departed from my written text considerably, which I often do, because as I look at the text, I feel sometimes the issues which might have to be brought to the fore are perhaps more important, more contemporary, more relevant, and where we should have a debate on even the existing models of, shall we say, policy determination, and also the way in which we statistically profile human beings and actually dedicate GDP. There is a parting comment. I have been very deeply disappointed at the amount of, shall I say, very disproportionate amount of attention paid to what might happen to business in comparison to what should happen to these people. They at least deserve equality in consideration. Even in terms of understanding their malaise, it is not their trials and vicissitudes which they are undergoing now, but what should be the way forward for them requires an idea. And that also leads me to believe that the time is perhaps ripe to consider that when we look at this right to health, is it not true that labor, they're called labor, that's only for the purpose of reference, but they're citizens, are they not entitled to the concept of a living wage, a wage which is consistent with some parameters of dignity which have to be actually redrawn by economists on a completely scientific basis, which must also factor in environment. One of the points which Sir Parthasarathy Dasgupta mentioned was that when you look at GDP, never look at GDP in absolute terms without ever factoring what damage it did to the environment. I think he was so far-sighted, extremely far-sighted, when today we see where we are. But thank you, my friends. Thank you for your patience, for listening to me. I hope we will have a very pleasant exchange. Yes, I'm open here.
Yeah, if you have, if any of the participants have questions, maybe
most
they can
welcome.
raise.
Most welcome.
Yeah.
Most welcome.
Hello, am I audible?
Yes. Yes.
Yeah.
Am
It
I,
would be great
am I
if you can.
audible, sir?
Yeah, you are
Yes.
audible, and it would be
Yes,
great if you can
Okay.
introduce yourself, please.
Yeah, yes, sir. Sir, I am Saurabh Sagar. I am a student in Rajiv Gandhi School of Intellectual Property Law, IIT Kharagpur. Sir, my question is that what I have been observing, or many of us might be observing, is that the political class is not holding each other accountable for their lapses. They are kind of giving them spaces, since knowing the fact that everyone is equally guilty. So, considering the fact that health is in a concurrent list, how do we see sharing the states and the center sharing the responsibility on this matter in a time of crisis like this?
I think that there should be actually on a time of crisis, even by an ad hoc measure, there should be what you call a national commission to deal with this problem. But that national commission must have actually direct control over relief to be given to poor people. It must have direct control. It cannot be that you have, say, lakhs of people assembled at one spot and nobody having even a clue. And in fact, I have a slightly different question to ask. I've been wondering at this question. All these people were employed by somebody. The employer did have their roles and dresses. What prevented actually employers from coming together and petitioning the government and offering at their expense that they would reach them safely? I have seen the most wonderful donations made to the PM's relief fund, extraordinary amounts of money. But what prevented the actual industrialists under whom they worked to arrange for their transport back home? I don't have a clue to it. And are we to believe that all of them have no identity? They are meant actually to just walk around in this hot sun, hoping that somebody is able to take them home. This is a case that there must be a national plan. The plan must be a national one. And I make three things very important. They are citizens. They have to be treated with total respect. They can't be pushed and shoved around. They have to be taken back home with respect. I mean, this is an egalitarian India in the year 2020. And in this year, there was a duty. For the first few days, I thought that it was all under control because it was a state of lockdown and people were being, one could see that there were newspaper reports of various people being looked after. But when we have crossed those days, now the ease down restrictions, ease down is happening. At this time, people want to go back. What happens? How are they meant to be addressed? I think there has to be understanding of the human situation. And it has to be a concerted understanding. And in fact, they can work together brilliantly, as we saw for a few days. We should really hope that there is a national commission, at least for the purpose of ensuring two things: that they go back safely and not this absolutely appalling sight of people being overtaken by trains or being thrown out of lorries. These are completely a stain on us. This is not a society which Dr. Ambedkar wrote about in 17 volumes. Dr. Ambedkar spent so much of his time, and let me explain this. He said that there will be a willingness on the part of the poor to behave as if they are the poor. And they are not, nobody is able to claim their rights. It is therefore a situation where I'm very, very clear that a national plan is essential. And that plan must take care of them. It is another thing that for the future, some measures may be in the mind. But in present time, they are the subject of human suffering. And governments have this duty to their citizens at this moment. The pandemic was not their invention. They did not go and say, please come here and visit us. Just because they don't have facilities, it is the duty of the government to provide facilities.
And sir, three more
Thank
people
you, sir.
have
Thank you,
raised
sir.
their hands. Maybe I can invite Mr. Arjun Philip George to
Yes.
raise this question. Yeah.
Hello, sir.
Mr. Arjun, yeah.
Hello.
Hello, sir. I'm from Central University of Kerala. So my question is that the complete disregard of the central government and various state governments to the public health infrastructure, whether it's contributing to the disaster that India is witnessing now, the increasing number of patients, the inability of the government to control this pandemic, whether it is because of the complete disregard for the public health, government controlled public health infrastructure, or whether it's due to the promotion of private healthcare institutions in metros like that of Bangalore and Mumbai, where the government doesn't have much facilities to take care of the citizens.
It's an excellent question, and Doc, I really congratulate you on the question. I believe, you see, in certain sectors under our constitution, if we are a welfare state, and I'm now using the word quite consciously, if we are a welfare state in the socialist sense, then there is meant to be a joint participation in certain sectors. Health is certainly one of them. In fact, the preponderance in health must be actually state actors. I mean, we have actually become, it is private, yes, but what about state? And all these, it should not be that this Prathamik Chikitsa Kendra becomes actually a small, a small building which has nobody inside it. It is locked. What is the point of the Prathamik Chikitsa Kendra? What are the items kept there? Where is the person there? So therefore, you are correct, in my view, because it is a question of health. The primary responsibility must be that of the state. The state can also, however, under a proper regulatory regime, permit private actors also to establish hospitals as centers of excellence, as some have done. I cannot say that there are no private hospitals of excellence. There are private hospitals of excellence. They do exist, but there is a duty for the state that it must take the lead in this today. If anybody has actually gone outside All India Institute of Medical Sciences in Delhi on any day, you will find that people are waiting for an appointment. And do you want to know where do they sit? Where do those people sit? They sit behind the bus stop, which is facing Safdarjung Hospital. Such is the queue for a government hospital, because people have faith in government hospitals. And there cannot be a doubt that hospitals, doctors in government hospitals, because of their experience and ability, are very competent and outstanding. It is time we give recognition to them. If you want also to have private hospitals, certainly you should have them. You should have a certain number of free beds in those private hospitals. But there is one very important aspect I'm making: regulatory control by a truly independent professional body. This truly independent professional body means without the ills of what we have seen in the past. We must have those who are actually truly connected with medicine to become the members of a regulatory body and assist the process of approvals. It cannot be that you give an approval for 5 years and suddenly the third year you say that we disapprove of you because we do annual inspections. Now, these are all important issues to be addressed in the private sector. And I have to make it very clear that there must be a preponderance of healthcare institutions from the government sector. The government sector can, even in some parts of their own functioning, take the assistance of the private sector. It is possible to have a joint sector partnership also at many places. And I think it is the need of the hour.
Yeah, sir, thank you so much for answering that question. And we have one more participant who wanted to raise a question. May I invite Mr. Prashant Patmanabhan, and I request him to introduce himself, please. Prashant, can you hear me? Prashant? Okay, I think there's some Prashant. I guess there's some connectivity issue there.
No problem.
Is there anyone else who wants to?
Yes, I see someone.
Yeah, I mean, 1 second.
Hi, good afternoon, sir. Can you hear me?
Yeah,
Yes.
if it would be better if we can
Sir,
introduce. Please introduce.
yes, sir.
yourself.
Hi, I'm Prakhar Pandey. I'm Professor Prakhar Pandey. I'm an assistant professor at Alliance University. At the start of the session, you mentioned that that health management should not be confused with public health, where you made a point about numbers and statistics. I'm wondering, isn't access to correct public health information also a part of right to health? Isn't that the state's responsibility, providing correct public health information to the public? I was just wondering if you could elaborate on that a bit.
I'm in total agreement with you. I maintain that access to information is a duty of the state, and access to information in favor of the citizen is the right of the citizen. It is completely a right of the citizen. And in fact, there's a duty to keep people informed. And one of the countries which succeeded in COVID-19, which was Vietnam, very strangely, was because of its excessive information sharing with citizens.
Okay, thank you, sir.
Yeah, anyone else who wants to raise the questions here, please? Maybe we can take maybe 1 or 2.
No, you take your time. I want to.
Yes, sir. This is Venkateshwara Rao. I have a question, sir. Can all the universities imparting legal education at LLB and LLM level should make it compulsory that health laws will be a part of the curriculum? Because few universities does not have anything related to health laws. That should be made as a compulsory subject. Can it be useful in the long run when these such type of pandemics come into existence? This will be useful for the for legal fraternity as well as the upcoming students. Will it be of help?
I'm in complete agreement with you. It should be a part of the curriculum.
Okay.
In fact, I will tell you, when I was a law officer and I had to deal with the subject of about additional frontline treatment to be offered in respect of HIV patients, with the assistance of some very brilliant lawyers, I was able to put together a report. And at that time itself, I thought to myself that this has to be made into a serious, it's a full-time paper, it is necessary. It is very necessary. Because you, as a lawyer, you would be self-conscious. Secondly, you would be able to teach other people their rights. and you would be able to remind hospitals of their obligations. I think it is very, very, very important. It's a very good suggestion.
Thank you, sir. We are on fact.
Sir, Mr. Prashant Pathanabhan,
Yes.
I mean, there's some problem with his mic, and
No problem.
he has raised his question in the chat box. He's asking, sir, what is your opinion
Yes.
about the Supreme Court and the High Courts dealing with the migrant issue? Do
Yes.
you agree with Fali Nariman's criticism of the Supreme Court, which appeared in Indian Express today?
What is that? What is he? Because I haven't read the newspaper today. I'm sorry.
Prashant, can you, I mean, hear me? What is there in newspaper today? What was the criticism? Even I haven't. Sir, that
No, I think I'm able to understand that Mr. Nariman must have been disappointed.
Yes,
that
sir.
adequate attention was not possibly paid.
Yeah, the criticism is that judges of high courts across India are soft-hearted, got established during the internal emergency of June 1975, when judges in 6 high courts, namely the high courts of Delhi, Bombay, Madhya Pradesh, Allahabad, Karnataka, and Rajasthan refused to accept that oppressive laws and orders were not longer reviewable by courts. However, these judgments of 6 high courts were over. Yeah, I mean, maybe I can just.
Well, I have already alluded to this in one of my talks, and I want to make my position clear. When there was an internal emergency, the institutions of justice were not shut down. They were not closed. Courts were functioning. Writs of habeas corpus were filed. They would be mentioned in Delhi. At that time, the Delhi High Court used to be in a building called Patiala House. In the first floor of the Patiala House, there was a division bench, which was earmarked to take up all writs of habeas corpus. That bench consisted of 2 judges, Justice M.R.A. Ansari and Justice Prakash Narayan. They would allow mentioning of the matters at 10 o'clock, service upon the standing counsel, the petition would be taken up at 2:30, and if no show cause was shown, a writ of habeas corpus was issued by 4 p.m. and the registrar was directed to inform the jailer to release the person who had been detained. So let us be very clear. There is actually no promulgation of emergency in this country, number one. Even when there was a promulgation of emergency, courts were not shut down. If the buildings cannot be accessed due to medical reasons or pandemic, alternate solutions have to be found. And I'm afraid, Mr. Nariman, I completely agree with what he says. These are all cases for suo motu cognizance. These are not cases for petitions by lawyers at all. These are all matters for suo motu cognizance. Such suo motu cognizance have taken place all over India in different circumstances. Gujarat High Court was one of the first leading high courts which took suo motu cognizance whenever they needed to deal with a problem which happened, which was not being brought before them through a petition, but which required judicial intervention. This is very necessary to bear in mind. The suo motu jurisdiction of the courts is completely intact. That is a jurisdiction, but that is a jurisdiction which only judges have to perceive whether it should be invoked or not. But yes, I read another report of a judge in Madras who almost wept when he spoke about the conditions of poor people. He was tearful. One understands this. And therefore, what Mr. Nariman says, that yes, that there was some amount of initiative taken by the judiciary, is perfectly understandable. In fact, suo motu jurisdiction exists in all courts. So wherever a court finds, within its jurisdiction, of course, if within its jurisdiction it notices something is happening, it has a duty, it has an obligation under the Constitution to discharge, which is to uphold fundamental rights of people. This, let us take the case of this Bandhua Mukti Morcha. Who was the man who came? A Swami came, called Agnivesh. A Swamiji called Swami Agnivesh came and stood before the court. And he filed a petition. And actually, even the names he didn't know. Who were these people hidden in different mining quarries in Haryana? Court appointed a commission. The Supreme Court has always appointed commissions to assist it in the enforcement of fundamental rights. And a commission went, and the commission got full details, and the court passed orders releasing all of them. The judgment in Bandhua Mukti was repeated again and again in different circumstances. So please bear in mind that the suo motu jurisdiction of the court to do what is right is an inherent power under the Constitution, to uphold the Constitution, to uphold the promise of people to the Constitution. That's very, very important. So what Mr. Nariman has written, if I may say so with respect, from what my colleague showed to me just now, it's absolutely, I completely support his position that this jurisdiction exists, and this jurisdiction must be liberally exercised because it is necessary for people in these circumstances. And I'm saying something else. Notwithstanding the best of efforts of government, we must also appreciate, I'm saying nothing at best of efforts. Even then there can be situations which require new innovative solutions. This is one thing we must understand. Best of efforts of government, most honest, even then, the court may be the only one which can devise new suggestions because it has a new access, it has access to so many resources. They can consult any number of social scientists to even deal with these situations, which under normal bureaucratic channels, you may not be able to do at all. Why is it that the bench presided over by Justice Venkatachalaya appointed a two-member commission, one of Professor Srinivasamurthy and Amita Dhanda, to go and give a report on the subject of mental illness? I happen to be Commissioner number 2, who went to ensure that the order of the Supreme Court was enforced and all mentally ill people were released from prisons. And you will be surprised to know, I took a board of 3 psychiatrists and none of them was mentally ill. And they were all in unlawful detention. Please understand, Supreme Court. And in Sheila Base's case, Sheila Base said, I am not liking the way these proceedings are being conducted. The Supreme Court said, all right, we will discharge you. But even if we discharge you, we are not going to shut this case. We are going to appoint the Supreme Court Legal Aid Committee as petitioner in your place, and the proceeding shall be conducted logically to its conclusion. Why? The Supreme Court was concerned about fundamental rights. So what Mr. Nariman, with his eminence, with his understanding, and after all, he himself, he was also aware at that time in the emergency. And please don't forget, we have had heroes. Mr. V.M. Tarkunde, never forget that one man, the one man, one great hero of the legal profession, V.M. Tarkunde. When people would not be even willing to file writs of habeas corpus or speak against the emergency, V.M. Tarkunde would walk in the corridor. People would not even like to be seen with him at that time. And he was quiet. He founded this People Union of Civil Liberties. At that time, there were two, the professors, that is Dr. Luthika Sarkar and Upen Bakshi, all of them came together to give some meaning that, well, civil society must be able to voice its views. There cannot be dissent. So please understand something, that the legal profession of lawyers and judges, including Mr. Narima, the kind of contribution which they have made in the field is enormous. So when he says that this suo motu jurisdiction exists, of course it does exist. It always existed and it shall exist. But as I said, these are matters of perception. And here the perceptions vary. Any two judges may not think the same way about a state of affairs. But it depends upon sometimes the ability to craft solutions. And now we have another problem, which is social distancing. Even regular courts cannot be held. Suppose, let us say, the judges did actually want such a solution to happen. They are already functioning under constraints even in the virtual courts. Because even for virtual courts, they have to maintain social distancing measures. Staff is not available. There are constraints. So I am assuming that there are constraints. But please bear in mind that the suo motu jurisdiction of the Supreme Court and the High Courts is completely intact to wipe the tear of anybody whose tear needs to be wiped in enforcement of fundamental rights.
Yeah, thank you so much, sir, for answering that question. And I can see a couple of more questions. May I invite Dr. V. Sudesh to raise his question, please. Professor Sudesh. Professor Sudesh, can you hear me? Yeah, Mr. Ayushman Khetrapal.
Yeah, hello, sir.
Yes.
Good afternoon, sir.
Please introduce yourself.
Sir, I am Ayushman and I have graduated from TERI 1 year ago, and now I am a practicing advocate in intellectual property. My query is regarding this current pandemic only. In the current pandemic, say if a cure or a vaccine were to be found and it was to be proven efficacious, however, since quite a lot of expenditure is being made in the R&D, it is likely that the company doing that research is going to get that patent, and then it is going to try to get some royalty out of it. So then it will become costly for common man and especially the poor to avail that facility. So in that scenario, do you believe that constitutional law can be used to bypass the rights of the patentee? Now, as we have seen in Remdesivir case, that Indian government was being asked to use provisions already available in the Patent Act, like compulsory licensing and government use of medicine in case of a pandemic, to make that medicine available widely in the public. However, the government chose not to do so because of its relation with the US, and already there are some trade-related issues with the US going on. So they chose not to do so. In that backdrop, Gilead already gave the royalty-free voluntary license to 5-6 companies. It was in the news a week back. However, the terms that they have created is that those royalty-free terms can be nullified if the pandemic was to end, or if alternative remedy was to be made available. However, the pharma companies know that while a pandemic may be over, some people may still require that medicine, or other conditions may be there, like other medicines may be provided, but they may not be as efficacious as this one, as beneficial as this one. So in such a case, do you believe that Indian court would be willing to step in and proactively and ask the patentee to provide royalty-free access to the medicine to the general public?
Well, one is there is a very, very lovely article by Justice Pratibha Singh in one of the papers where she discusses this question in the context of a vaccine being found and what are the possibilities, the measures which the government has under the patent law. That is you should have a look at the article. It has very useful suggestions. Well, I would say that I would anticipate it without prejudice to the rights of any patentee. The court will always try to see what is preferable in public interest. It is not that the court will extinguish the rights of the patentee if he's entitled to a patent, but would strike a ground which is consistent with public interest. It did so in the Novartis judgment. So the other thing which you must also understand is this is a pandemic. This is not a case where we are looking for an alternate drug which is good for diabetes too. This is a serious pandemic where a man can die within barely, let us say, 6 to 8 hours. It depends upon the nature of the cytokine storm which happens within the body. Therefore, the number of different companies which are actually investigating possible vaccines is also because this is the first time the R&D as well as the ability to come forth in a humanitarian crisis has been triggered. This is a one-time crisis. There has been no crisis like this after Spanish flu. And in Spanish flu at that time, we hardly had any of these giant pharma companies. We also did not have means of artificial intelligence to be used with the help of knowing how could chemicals be used. Today, you have actually multiple tetrabytes of readily available, shall we say, candidate compounds. Now, to see which one is going to use it requires different kinds of technology. That is why, if you ever look at the website, 179 different attempts are being made by companies to arrive at the vaccine. There's, you have Moderna, you have Oxford, you have everybody. Everyone is attempting to bring forth a vaccine. But ultimately, it will be the terms upon which the vaccine is made available to the citizens of India, where governmental oversight and intervention may be required if it is necessary. It is quite possible, as did happen with some vaccines, including the polio vaccines, as it did happen, that the WHO and other instrumentalities, they took great control over the fact that these must be sold as freely, negligibly, if not at no cost. So even that can happen. So it is all a matter of conjecture. But yes, courts do have the power, and and the way in which a judge who herself practiced intellectual property as a lawyer has written about it and saying that these are very unusual situations where governments may have to consider the powers which exist under the Patents Act, but whether the situation comes to that stage is still a matter of conjecture.
Sir, I was asking that if the government chose not to do so, to exercise its power granted under the Patent Act, then would the court be willing to take a suo motu cognizance and interfere?
It could not. It is not my, I can only, it's a matter of conjecture.
Okay, thank you, sir. Thank you.
Yeah, sir, can we take a couple of more questions?
Sure.
Yeah, may I now invite Professor Sudesh from University Law College, Bangalore, to raise his question, please. Dr. Sudesh, can you hear me?
Yes, I'm hearing you. I'm hearing you.
To the dialogue that we had just now. So my specific question is, as far as the migrant workers are concerned, has there been a systematic failure? Number one, the NHRC was too late in flagging of the issue. Number two, the trade union themselves, who commit themselves for the cause of the workers, they never flagged off this issue. Number three, there was a failure of the implementation of the Interstate Migrant Workmen Act in terms of payment of displacement allowance, journey allowance, and other facilities. Yes, sir. That's my question. Systematic failure.
I totally agree. I totally agree. And actually, I mean, a Human Rights Commission calling today After how many days? What is the day when this has happened? I mean, I'm not able to follow. It is delayed. And these laws, and you are correct, I cannot believe that there is such lack of collective bargaining in this country. It is unbelievable. It is so unbelievable. I doubt if Indrajit Gupta, the former member of parliament, was alive, would this have happened? I'm just mentioning one name. Would this have happened? It is a very serious point that labor laws simply collapsed. However, look at a place where social consciousness is high, right? Where power structure is not all that power structure. You take Kerala. How is it that in Kerala, the government knew every district, every village, every lane where people who were affected were living? It was possible. But the way in which the migrant workers, Interstate Migrant Workers Act, these labor laws, and somebody thought of even suspending the labor laws. I mean, I really think we have to think at this. And as I said, there has been a complete lack of representation on the part of the poor. And there has been lack of collective bargaining. They have not been able to speak in one voice and seek at least their basic demands. I'm very sorry. There has been a lack of collective bargaining.
And sir, now we have Ms. Divya Dwivedi. May I invite Ms. Divya Dwivedi and kindly introduce yourself, please. Divya, can you hear me? Divya? May I invite Mr. R.P. Singh? Mr. R.P. Singh? Is there anyone else who wants to raise their queries, please? I think, so that's it.
Dr. Vishnu, if you may permit me.
Yeah, yeah, of course, please.
Yes, sir. Sir, my question is on the Arogya Setu app.
Yeah,
The
can
app.
you introduce yourself, please, Vidhi?
Yes. Sir, I'm Vidhi. I work with the Center for Postgraduate Legal Studies at TERI School of Advanced Studies.
Please.
Sir, my question is related to Arogya Setu app. Serious legal and privacy concerns which this app raises. So how do we juxtaposition the right to health and right to privacy in this context? Your guidance on the same.
I'll be very clear. I have fought for privacy, and I have led arguments that it is an inherent human right.
Right.
But even I would say, in these exceptional circumstances, until we arrive at a certain, shall I say, a point of time when the Setu app will not be needed, until that point of time, maybe it is necessary. You see, so up to a point of time, it may be necessary. So we may have to give respect to that position. So this may be that extraordinary position, because this disease is such a virulent disease. It actually, nobody knows how it comes. I have not had any clear explanation even till today about how people get infected. But one thing is, because of the overwhelming nature of this disease, the use of this app at this juncture, notwithstanding the general concerns of privacy which we have, I would say that yes, it should be used until, and I'm saying It should be a need-based requirement, after which it should be dispensed.
Thank you, sir. Thank you.
Yeah. Is there anyone else who wants to interact with Mr. Gopal Subramaniam? Hello. Miss Divya Divedi, Mr. R.P. Singh, are you there? I think, sir, I mean, that's it. We have no more questions. And sir, thank you so much for having this webinar. And I, on behalf of the TERI School of Advanced Studies, on behalf of my students and colleagues, would would like to convey our thanks to you. And I also would like to take this opportunity to thank for the 2 awards that you instituted for the meritorious LLM students in the previous batch. And because of the lockdown, it has been delayed. The distribution has been delayed a bit. Immediately after the lockdown, we'll be distributing it, and we'll be sending you the required report. And thank you so much, sir. Yeah.
Thank you very much, and thank you all of you. And you have been very kind. You've listened to me for a long time.
Thank you, sir. That was really very proud.
Thank you, sir.
Thank you.
Thank you so much, sir.
Thank you.
Thank you, sir. Thank you.
Thank you very much.
Thank you.
Thank you.
Thank you so much, sir.
Thank you.
Thank you.
Thank you.
Thank you very much, sir.
Thank
बहुत
you.
बहुत शुक्रिया
Very-
साहब. बहुत बहुत शुक्रिया सर. बहुत बहुत शुक्रिया.
Thank you.
Thank you.
Sir, now you may leave the webinar.
Yes.
Yeah.
Thank you.
Yes.